Right now, public protector investigation into robbery on the president's farm doesn't put President Cyril Ramaphosa in a position of conflict to exercise his official duties. The High Court in the Western Cape has heard. His legal team has been challenging arguments that he's too conflicted to suspend Busisiwe Mkhwebane from her job pending Parliament's impeachment inquiry. Lindsay Dentlinger has been following arguments for the second day in that court. Lindsay, why does the president's legal team believe he can still exercise his constitutional duty to suspend Mkhwebane?
So, Maseko, you will recall yesterday that this issue of the Phala Phala farm investigation really playing into the argument that the president is too conflicted to exercise his duties and that he suspended the public protector because he wanted to get her off that investigation and therefore was acting in a retaliatory manner. But we're hearing arguments from the side of the presidency today saying that the test really was whether a personal matter, which the presidency contends the Phala Phala farm robbery saga is, puts the president in conflict in terms of carrying out his official duties, which by virtue of the Constitution he is allowed to suspend a public protector pending dismissal proceedings. And it is the contention of the presidency here before this court today that no such conflict does exist and that the process leading up to the suspension of public protector Busisiwe Mkhwebane started way back, long before this Phala Phala matter came into the public domain, and that it was all really just a matter of that timing. You will recall that the president announcing that he was going to suspend the public protector less than a day before the same court was due to hand down a judgment which the presidency says they did not know at the time that judgment was going to be handed down the very next day, which would also then chart the path in terms of Parliament proceeding with its impeachment inquiry. But let's just listen to the legal counsel for the presidency, Carisha Pillay, putting it to the court why the presidency does not believe that this Phala Phala farm saga puts the president at conflict in terms of carrying out his duties and determining whether or not to suspend the public protector.
That there is a private interest at stake. It's the president's private interest at stake. And so the question is there a risk? And we submit at the level of legal principle, there is no risk because of what the Public Protector Act provides for in 2A7 and in any event because of Section 13 of the Public Protector Act. And whatever the Advocate Mkhwebane may, however she may view that pending investigation, the truth of it is the President's evidence is that he is cooperating fully with that investigation. There's no evidence before this court to contradict his statements in that regard. And so the question then becomes, Justices, with respect, can it be said that because there is a new investigation before in relation to the President, that now gives rise to the conflict at this stage?
So the DA is currently making its argument. What's its view on whether the president should be presenting his Phala Phala responses to the public protector to the court?
Well, Maseko, if you didn't know that Stephen Budlender is representing the DA here in proceedings this afternoon, you would think he was also batting for the president. He's saying that even though the Democratic Alliance has been vehemently opposed to the way in which the president has been handling this Phala Phala matter, it's insistent that he comes clean, so to speak, and take the public into their confidence of exactly what happened on that farm. In this particular instance, Stephen Budlender for the DA arguing that this matter has no bearing on this case as to whether or not the president was fair or acted prematurely in suspending the public protector, or in fact acting in a retaliatory manner, which is the argument put forward by the complainant here in terms of whether or not he was going to suspend her. And in fact going as far as to say that the public protector was putting on a spectacle before this court, repeatedly coming back on this particular instance, and says if you go back on the chronology chronology of events pretty much similar to what the counsel for the presidency has been saying, that there's been a long process that led up to the president ultimately taking that decision to suspend the public protector, and that whether by design or not, once the Phala Phala matter entered into the public fray, that it cannot be considered a reasonable argument to suggest that the president was acting in a manner trying to interfere with that investigation in any manner, or to impact the way the Public Protector's Office was going to carry out that investigation. And so for that reason, saying that do not feel that despite what his clients feel about how the president has been handling this Phala Phala matter, this court is not the place, and this case more particularly is not the place for that matter to be ventilated and to have any impact on what this court is being asked to consider. Here's Stephen Budlender for the DA.
The DA has been sharply critical of the president's conduct with relation to Phala Phala and has called for parliamentary investigation. So I hold no brief for the president. But the DA's position is to say that the Phala Phala issue, as serious as it is, cannot be allowed to obscure Advocate Mkhwebane's wrongdoing and the need for her to be suspended, and the fact that her suspension was lawful. So I will ask you not to ask the question whether Phala Phala matters or not. Of course it matters. But the fact that it matters doesn't mean that Advocate Mkhwebane was unlawfully suspended. The two things just don't follow.
All right, Lindsay Dentlinger live for us in the Western Cape High Court. Let's leave it there for now.